As already we have discussed that the Hanafi school among the Sunnis classified preemptors as Shafi Sharik, Shafi Khalid and Shafi Jar. So as to the Hanafis, the first classified category of preemptors as Shafi Sharik, they mean the co-sharer in the property. As a co-sharer, he has the right to preemption or Shufaa on the sale of the property. And the second preemptor, according to the Hanafi school, Shafi Khalid, is a participator, so has the right of preemption or Shufaa only in respect of right to way and right to water and no other rights. And regarding the third category of preemptors, Safi Jar, who is the owner of an adjoining property, who is a neighbor, the right of preemption or Shufaa does not extend to the tenant or to any other person in possession of the property and not even to the Waqifs, Mutwali and God. The right of preemption or Shufaa restricted only to houses, garden and small parcels of land and not to the larger estates like jamindaris and jagirs. So these are the three classified categories of preemptors among the Hanafi schools. And now we'll go to right of preemption as it was found among the Sunnis and Shias and as it was interpreted in the leading case, Pasha Begum versus Said Sabu Hassan in 1956 by the full bench of 5 judges of the Hyderabad High Court held that as preemption is claimed on the basis of business and as the vendor is Shia and the preemptor is Sunni, so there is no right of preemption as it is not recognized in Shia law. Further, the court held that if the Bhandi and the preemptor belong to the same school, then the rules of preemption of the school to which the parties belong will apply. And further, their lordship held that under Shia law, the right of preemption cannot be claimed by a non-Muslim in preemptor, where the vendor and the vendee are Muslims. In Islamic law, when a Muslim wants to sell his property, he is obliged to sell it to his neighbor or to the co-sharer. But a non-Muslim vendor has no such obligation. So also a Muslim cannot claim the right of preemption against a Hindu Bhandi. So now we'll go to the other aspects of Sufa, such as the conditions for demand of preemption. So regarding that, When there is transfer of property through sale and exchange, the sale must be complete, bona fide, and valid. So also, the exchange must be unconditional, complete, and subject to be bona fide and valid. And if the exchange is subject to either return back during the lifetime of the parties and cancellation of it, then there is no right of preemption can be claimed. There is conflicting opinions regarding transfer of property to his wife in lieu of dower, as some held it as sale and others held it as ibaj, the right of preemption under Islamic law does not applicable in respect of a gift or sadaq or waqf or inheritance or bequest or lease and mortgage. The controversy on whether a sale is completed under Muslim law is valid or under Transfer of Property Act, and it was decided in the leading case Radhakrishna versus Sirdhar and others in 1960 by their lordship of the apex court or the Supreme Court. So, the apex court held that a sale will be complete in accordance with the provisions of the Transfer of Property Act, and Muslim law cannot override any other personal law, the very provisions of this act. So the Muslim law of sale has been superseded by the Transfer of Property Act. So now we'll go to the very formalities as provided regarding preemption or Shufaa, and as it was mentioned in detail in Hidayah. So, according to Hidayah, the most authentic source of Islamic law, these formalities, and as it provides the formalities called as the first one, Talab-i-Mowasibat, Talab-i-Mowasibat, and the second one, Talab-i-Ishhad. So, Talab-i-Mowasibat, or the first demand, which means the preemptor must express, I do claim Shufaa in clear and unequivocal terms, and it must be made as soon as the fact of sale became known to the preemptor. And as regarding the second one, Talab-i-Ishhad, or the demand, which means the preemptor must express such and such person has purchased the land of which I am the Shafi, and I have demanded preemption and now do demand it. Bear you witness to this. And regarding the third one, that was developed by Fayji, and besides these above two demands or formalities, Fayji considered that there is a third demand, and that is filing of the suit to claim the right of preemption. So, these are the three formalities as regarding preemption and Shufaa. And the first one, as it was mentioned, I.Talab-i-Mowasibat, the preemptor, has to assent his claim immediately on the hearing of the cell, but not before. And it is called the first demand. Any improper, unreasonable delay will imply not to exercise the right of preemption. Here, presence of witnesses is not a legal requirement as it is made by the preemptor in person. The demand may be made by his manager or a person authorized by him. Even a de facto guardian of a minor preemptor has the right of preemption on behalf of that minor. This demand to be valid must be made when the sale is complete. Without it, it is totally ineffective. So the first demand or I.Talab-i-Mowasibat must be made after the registration of the sale deed, and the second one, I.talab-i-ishhad, soon after the first demand, the preemptor should assert his right by making the second demand in the presence of two witnesses. Such expressly called to bear witness to the second demand in the presence of the vendor if he is still in the possession of the said property or in the presence of the buyer of the property. It is sufficient if two witnesses are present, and the preemptor should not tender the amount with the sale price. It is sufficient if the preemptor expressed to purchase the property at the same price as was paid by the purchaser or the vendee. So, when two or more persons claim the right of preemption, then each one of them should make both the demands separately unless one is authorized to make the demand on behalf of another. It out of the several preemptors, only some of them has made the demand, but all of them file a suit. The suit of those made the demand would stand and others would be dismissed. So, in our next video, we will discuss regarding Fai's opinion of filing of suit, and that is the other form of preemptor, that is Talab-i-Tamli, and that we will discuss in our upcoming video.